The State of Crypto is presented by Tron, connecting the world to the power of cryptocurrency.
All right, okay. The SEC is alleging that crypto exchange Bittrex simultaneously operated a national securities exchange, broker, and clearing agency in violation of federal statutes. Joining us to discuss is Morrison Cohen LLP partner Jason Gottlieb, who is also the chair of Morrison Cohen's Digital Assets Department. Jason, it's great to have you.
Thanks. It's great to be here.
All right. So, just give us a sense right now of what's going on, because you have crypto clients and and you basically defend companies and individuals in this space, in this digital asset space. But what do you make of this latest move by the SEC?
Well, ever since the fall of FTX in November, the SEC has shown newfound aggression in going after crypto markets and players in all aspects. We've seen publicly the Wells memo, the Wells notice that was given to Coinbase, and now we've seen not just that Bittrex received a Wells notice, but also received a complaint filed in federal court alleging that Bittrex has been affecting transactions in securities, doing broker-dealer activity, and performing the functions of a clearing agency, all without the proper SEC licenses, which of course is all dependent on tokens on the Bittrex platform being securities.
Yeah, all right. Okay. So I guess the other thing that we've been looking at is what Bittrex said about that. And one of the things that they said, that the regulator had refused to flag the tokens it thought was securities. How can you really fight something like this in court is something we've always been thinking about. How long will this fight really take if it reaches court? Several companies have said that we will be ready to, take on legal action if required. I'm just trying to get a sense of, if this does pan out towards the legal route, how long does this take, and what are you advising your clients?
Well, unfortunately, the legal routes can take a very, very long time. Everyone in crypto is used to things moving in microseconds, but court actions are not quite like that. As I'm fond of saying, we are litigating neuromancer issues at a bleak house pace. We can see the action against Ripple is just past the summary judgment briefing phase. We're still awaiting a decision. That's been pending for several years. And if Bittrex chose to fight this case to the end of it, we could be in for a fight that's several years long, particularly given the complexity of the fight that the SEC has picked. They essentially said that Bittrex was letting 300 crypto assets trade on its platform, and then they just picked 6, I guess, as some sort of sampling. And that forces Bittrex to defend all 6 of those and explain why they are not securities.
So one of those 6 was Algorand. And what's interesting is that there's been this video floating around as of yesterday of SEC Chair Gensler back in 2019 saying, very nice things about Algorand and how he knows the founder. I don't know if they had coffee. They might have had, the brandy over drink, a couple of nights ago, whatever it is. It just seemed very friendly. Can Bittrex use that almost praise of Algorand in their defense to say, hey, look, we asked you to say something, you didn't say something, we went by Gensler's previous comments that how great Algorand is, it's fantastic, it's wonderful, you can build Uber on it. Can they actually use that to save themselves?
Well, they can use that video, but the video is going to be more atmospheric than legal, a way of showing that Gensler's been somewhat hypocritical on this subject. But saying something in the past doesn't mean that Gensler can't turn around and the SEC can't turn around and say, okay, well, we said that then, but now we think it's a security and we're going to prove our legal case. However, there's another element at play here, which is the fact that many of these things were said a long time ago. The complaint opens up by saying that the Bittrex platform was making available this trading from starting in 2014. If you look to all of these tokens that are trading, the SEC is alleging that the OMG initial coin offering was in June 2017 and started trading on Bittrex the next month. Dash has been available for trading since 2014. So these tokens have been trading for a very long time, and there are excellent questions about whether there are statute of limitations issues that apply. So it's not just that Gary Gensler said some nice things about Algorand, it's that these things have been out there, have been trading for longer than the statute of limitations period. It's a complicated legal analysis on statute of limitations, but there is some legal headway that I think companies in this position can make.
So, and you think that they'll be successful, though? I mean, is that something that has in the past, or any precedents here, where they said, "Look, you know what? We've been doing this for a long time. You didn't say anything. We asked you. You didn't say." You said, "Yeah, I don't know. Who knows what it is?" And they just let it happen. So, I mean, does that grandfather clause, if you will, really work in courtrooms?
It does. It does. Now, the statute of limitations, as I said, is very complicated. So there are a lot of it depends. It's every lawyer's two favorite words. It depends. A lot of it is going to depend on the facts and what is being alleged in the complaint. But I do think that there are some very effective statute of limitations arguments that can be employed here and in other instances where the SEC is complaining about tokens that were first issued or traded more than 5 years ago.
Jason, hi. It's great to see you on the show. So I want you to just break down something that I know you have special expertise in, is that you have actually advised various crypto companies to work with the SEC, right? And there's basically this huge controversy within the crypto community where you have crypto companies saying, we're trying to work with the SEC and there's just no way. And the SEC saying, all you have to do is fill out a form. I was wondering if you could break that down for us, because that's sort of at the crux of this whole thing about crypto companies leaving the United States, is that there's two totally different narratives here about if it's even possible for crypto companies to register with the SEC.
Great question, Emily. You're absolutely right. Look, the law is the law, and it says what it says. So if you are issuing securities, you have to follow the law. The question is, what is a security? And the law is supposed to be very flexible about this, but we don't have very good clarity. And we don't even have very good clarity on when a token is a security, much less all of the hundreds of different regulations that apply to securities and how they would map onto the software that is a token after the initial sales. We just don't know how this works. So over the past 6 or 7 years, myself and many of my colleagues, we've gone to the SEC with clients and sometimes just on our own to say, well, tell me, how does this work? If you want us to register as a security, we're happy to register. We're happy to disclose everything. We're happy to do whatever it is you want us to do to follow the law. Tell us how to follow the law. And what we hear again and again and again is, sorry, we can't give you legal advice. You need to figure that out. So then we come back to them with lists of 5, 10, 20 questions. Okay, well, how does this work? How does this work? How are we supposed to make these disclosures? How do we fill out these forms? There's no place on the forms for these kinds of technologies. What happens after the 1-year period? And unfortunately, there are no good answers to many of these questions, and the SEC staffers sort of shrug and say, sorry, we can't fix that. But that leads to this incredible problem where they're telling us, just come in and talk to us. Just come in and register. All you have to do is follow the law. But we're dealing with technologies that are not susceptible to the regulations because the regulations were not built for these technologies. So right now, there is no good, clear path to offering a token that is not a security, to running a cryptocurrency exchange for products that are not securities. The SEC just says, follow the law, but then it won't provide regulations that can be followed. And as a result, Emily, as you persuasively put forth in a CoinDesk article, and there was a follow-up from your colleague, Jeff Wilser, companies are saying, we've had enough of this. We're leaving the United States. We literally can't legally operate here. So they're moving operations offshore, they're moving businesses offshore, they're moving employees offshore, because the United States is just not a friendly place to do crypto business anymore.
So, Jason, thank you for mentioning the article, but I have to say you've been warning about this even earlier, so we really should be thanking you. But so I guess what is your advice? I mean, you're a lawyer. I know you're not our lawyer, but you are a lawyer. What is your advice to crypto companies that come to you and say, "Hey, I have this really cool idea. I want to register in the United States." Well, what do you say to them?
Well, remember every lawyer's two favorite words. It depends. But a lot of the time, we unfortunately these days have to advise, that's a great idea. You can't do it here. or there is significant regulatory risk to doing it here. So what we have to do is essentially teach them how to not be in the United States, how to offer overseas, and try to refer them to our colleagues in the EU and in the UK and Singapore and Japan and Korea, Caymans, BVI. All of these jurisdictions are developing legal regimes that can allow people to operate legally. And people may not like the regimes. They're not perfect. Each of them has advantages and disadvantages, but they all offer one thing that the United States does not, which is a clear path to operate legally. So we try to tell our clients as best we can what the law requires, what the regulations require, and what they can legally do here. Sometimes we can structure businesses so that they can operate legally here, or at least as close to legally as we can possibly figure out, given the ambiguities from the SEC. And sometimes we have to tell you, sorry, it can't happen here.
Do crypto companies have a case to say, hey, look, you know what? It seems as if the SEC is telling us everything's illegal unless we say it is legal. Is there? It's kind of against what we know as law in the United States, where everything is legal unless it's specified as illegal. Do they have a case to say, look, this is kind of not the way it's supposed to go? Can they force the SEC to specify what is a security and what is not, and lists of when they're asked?
I think we're going to start seeing more of that. Since the Supreme Court enunciated what it calls its major questions doctrine a couple of years ago, more and more, we're going to see crypto companies trying to push back against the SEC. What the SEC's rulemaking process is doing here, when it's saying you have to be registered, but you can't be registering, their essential view on regulation is simply no. You can't do it. You can't have crypto business here. And what the Supreme Court has instructed is that administrative agencies, which are a branch of the executive department, are not allowed to take views that will affect major questions of the United States economy, because that's in Congress's province. That's for Congress to set the law, not for the SEC to say, we believe the law should be no crypto. So increasingly, you're seeing companies push back through the major questions doctrine and other related doctrines to say, this is not fair, this is not right, this is not American. It's one thing to have flexible securities laws, and we should have flexible securities laws so that every 10 years or so, when somebody comes along and says, my thing's not a security, it's a biffo blammo, the SEC can say, no, that's just a security, that's the same thing. But when someone comes along with something that is truly different, and crypto is truly different, there should be some avenue to say, no, this truly is different, and it is a major question of central importance to the United States economy. Therefore, you can't simply say no.
It's funny you say that. SEC Commissioner Hester Peirce had actually indicated that in an interview to CoinDesk just yesterday, where she said that the Congress has actually given the SEC the power to make those flexible changes if required, to make that call, but they're not doing it. And she herself is an SEC commissioner, so we kind of have to believe her. But thank you, Morrison Cohen LLP partner Jason Gottlieb. That was really cool to have you on the show once again. Thanks so much for coming on.